My name is Sean Nation. I'm Deputy General Counsel and the Interim Director of the Center to Keep and Bear Arms at the Mountain States Legal Foundation here in Lakewood, Colorado. I speak today to address some of the clear constitutional infirmities in 24-1292. In the first instance, neither the legislative findings nor this committee have attempted to meet the state's burden under the standard enunciated by the Supreme Court in the Bruen case. And it is the state's burden to show that the bill is in line with the country's history and tradition of firearms regulation. That is the test that the bill will be evaluated under. And simply put, it is not. There is no history and tradition of banning cosmetic features of semi-automatic firearms. In the 90s, during the federal ban, manufacturers easily designed around, but there is no analogous law from the founding period, and that's what's relevant under the Supreme Court's precedent. That is the legal framework that a reviewing court will use to determine whether the legislation is constitutional. And I urge this committee to consider whether, emotions aside, the bill complies with that constitutional framework as outlined by the Supreme Court. I also want to raise an issue that I don't believe I've heard anyone raise today, and that's the Eighth Amendment. As you hopefully know, the Eighth Amendment bans excessive fines, and a $250,000 fine as a civil infraction is likely to be viewed by a court as excessive and unconstitutional. I certainly understand the urge to do something, but I implore you to think long and hard about whether this legislation complies with your oath to uphold the Constitution. Thank you.